Hi, good afternoon, everyone. I'm Charlie Wen, Associate Professor and a member of UNSW Law's Herbert Smith Freehills CIBEL Center. And I'm delighted to welcome you to the second session of the 2021 CIBEL webinar series. The topic of this webinar is e-commerce, RCEP, and the ways forward. I would like to begin by acknowledging the Bedigo people who are traditional custodians of the land where UNSW Law stands. I would also like to pay my respect to the elders, both past, present, and emerging, and extend that respect to other Aboriginal and Torres Strait Islanders who are present here today. As I mentioned before, distrust, geopolitics, and populism are chipping away the achievement of globalization in the past decades. We are facing the challenges of the pandemic and a more fragmented world. Luckily, there is a piece of good news for globalization at the end of 2020. Regional Comprehensive Economic Partnership, short for RCEP, has been formed. It covers 15 countries in the Asian Pacific region and has almost 1/3 of the world's GDP. People in the partnership now have some concerns about their e-commerce market in front of the world-leading e-commerce conglomerates from China, such as Alibaba and JD.com. Whether they will bring prosperous or disputes for partner countries has been under a heated debate at the moment. I'm glad to announce that we have two great law scholars on the panel. They are bringing us two fantastic topics on RCEP relevant to e-commerce. The first speaker is Professor Xu Duoqi. Duoqi is a Director of the Center for Law and Digital Economy, Fudan University. She is a professor at Fudan University Law School and affiliated professor at the Shanghai Advanced Institute of Finance, Shanghai Jiao Tong University. She obtained her PhD from Wuhan University. Her research focused on fintech law, cybersecurity, tax and fiscal law, and others. Professor Xu has published over 80 papers. Many appeared in SSCI indexed and CSSCI indexed journals. She has visited and taught at Harvard University, New York University, Duke University, University of New South Wales, National Taiwan University, and other academic institutions worldwide. She now serves as a standing director of a China Law Association on Science and China Association for Fiscal and Tax Law. She's also the legal advisor of several governmental institutions and arbitrator of several arbitral bodies. Her talk today is Rethinking Notice Takedown in China's e-commerce law. The second speaker is our very own Professor Heng Wang. He is a professor and a co-director of UNSW Law's CIBEL Center, the largest center in the field outside China. He is also a co-director of Xinhua UNSW Joint Research Center for International Commercial and Economic Law. Heng has been recognized domestically and internationally for his outstanding contributions in international economic development and Chinese law, including being named Australia's research field leader in international law by the Australian newspaper Research 2020 magazine. Besides books, he has published extensively in journals in English and in Chinese. Today, his topic is RCEP and its implications. So the first speaker is Heng. His topic is RCEP and its implications. Heng, please.
Okay, so thank you, the chair, for the kind introduction. I'm very glad to be here to share my thoughts about RCEP and the implications. So what I would like to see, if you see our outline, please go to the next slides, please. What I will talk about is about general introduction of the RCEP and the RCEP itself, and what does RCEP means. I hope that will lay a basis for the great talk by Professor Xu on domestic law issues. So if we move on to the next one, we see that let's look at what are the RCEP. So RCEP is basically, as we know, that is the largest free trade agreements in the world if we look at the GDP and the population. So there are 15 states, and actually all of them are kind of related to ASEAN, the Association of Southeast Asia Nations, because they are partners of the ASEAN, and Australia, China, India, Japan, Korea, and New Zealand. Although they are, the India eventually has not signed the RCEP agreement, but the other countries has been proceeded on the RCEP agreement, and they have signed these agreements in November 2020. And there are up to now a number of countries, including Japan and China, already ratified the RCEP agreements, and the RCEP will enter into force 6 days after 6 ASEAN member states and 3 non-ASEAN member states has ratified this agreement. And they also have the planning down the track for the future rules in the trade area, including the topics we'll touch upon today, like e-commerce. So let's look at the next slide. What we'll look at now is about the next slide, which tells us, here you see the issues covered by the RCEP in 20 chapters. So basically, RCEP is kind of the trade agreements, largely modeled after the the WTO, World Trade Organization rules. So we can understand that from, if we look at the e-commerce, for example, you also involve issues like trading goods. You sell goods online. So one of the major developments of the RCEP rules in goods is about trade facilitation. So which means that they have a simplified customer procedures for goods, and also of course we see that e-commerce also involves services. Services are quite intertwined with e-commerce. If you think of logistics, services, you sell your products online, but you definitely need to have logistics service to deliver that to the consumers. So there are provisions, regarding various services, and also they may also relate to, for e-commerce also you may need financing that relates to financial services. So they have promoted more service liberalization in areas like financial services, and also to ask for dialogue to promote recognition of professional services. And also they have RCEP also deal with some other issues related to e-commerce, like investment, because if you want to promote e-commerce, you may want to establish a presence, warehouse or sales representatives and so on and so forth in other countries. So that involves investment, which is also covered by RCEP, and that includes also investment facilitation. And it should be noted that actually, that the RCEP does not include the provisions on the investor-state dispute settlement. So this is an issue which has not been dealt at this stage. And of course, that for e-commerce, there are specific dedicated chapter on e-commerce, which, if you look broadly, it's more like kind of similar to what you see in the CPTPP or the TPP framework to some extent. However, the rules are also relatively different if you compare them in more detail. For e-commerce chapter, which we see that actually the members has agreed that they will not require data localization. So it's no requirement that you need to have your data server in one country before you can conduct business. And there's no requirements for restriction movement of information in relates to e-commerce. However, there are important caveat is that this kind of data localization barrier removal or the movement of information, facilitate of movement of information across borders, only are subject to national security or essential security exceptions or public policy exceptions, which means that if the regulator deems that it's necessary for national security or essential security or public policy, they may still require you, to localize your server or have some restrictions on information flow. So, which means that actually at the end of the day, the implementation of those kind of the rules will rely on the specific domestic regulator. So it's being a more open issue to be seen in practice. So that also means that for businesses, the e-commerce regulations are kind of moving targets, because that depends on how countries interpret the essential security, as well as issue like the public policy. And the second aspect which I want to mention about e-commerce, which is a kind of good news for for business side, is that there's no customer tariffs on electronic content or transmission. So basically, it means that unless there's any new developments in the WTO, the e-commerce, electronic content or transmission, they're not subject to customs duties. And also, another aspect we should look at for e-commerce is that actually, if you look at dispute settlement, the dispute settlement mechanism of the RCEP does not apply to the e-commerce chapter. So which means that if there's any disputes in the regulation of e-commerce, they heavily rely on the discussion or conciliation or negotiation among the parties. And the fourth point in e-commerce we can think of is also the commitments in the e-commerce will not apply to financial services sector. So which means that actually the e-commerce chapter rules will not apply to the financial sector. And the fifth point which I want to highlight in the e-commerce chapter is that also there are rules to call for the protection of consumers, privacy and dealing with the spam. So the countries of RCEP area shall implement measures to protect personal information, to deal with spam messages and protect the consumers from misleading content. And also, one of the final points in this part is also the call on the cooperation on e-commerce and cyber security, and also call for more transparency in the sense that the countries shall publicize, their regulation regarding e-commerce. And that also relates to the issue about facilitation of the cross-border trade. You try to support, the use of electronic signatures, electronic authentication, and to promote a more digital version of trade administration documents. So in this way, they like to help to remove some of or streamline some of the burden that e-commerce business may subject to in the RCEP region. I should say that for the e-commerce chapter, I think that many of the rules are still aspirational. So which means that they also rely heavily on the willingness and also of the regulators at the domestic level to deal with that. So the RCEP in e-commerce does not provide for uniform regional-wide standards for how much protection or standards you should stick to for e-commerce. So that's basically a major point in this chapter. And also, now I would like to move on other chapters, which also potentially be relevant to e-commerce. One is intellectual property. They also have more, rules on that. One of the major developments that enable firms to file a single, patent or trademark application, so that avoids you to go to different jurisdiction to apply for your patent or trademark registration. And they also have a rules on government procurement, competition, dispute settlement, as well as issue like other issue like small and medium-sized enterprises, and also call for economic and technical cooperation. I should say that actually there are no chapters in the RCEP regarding the environment and labor. So social issues like environment, labor has not been dealt with in detailed rules under RCEP. So with that, I'd like to move on to the, let's look at the next slide. So then the question we have is what does RCEP mean for businesses or for regulators? For, if you look at for the lens of the e-commerce from goods, it definitely means lower cost. So presume that based on the presumption that every country will implement RCEP rules faithfully, instead of avoid the rules, or then we expect that there are preferential tariff outcome which can can benefit the businesses and also the consumers. And also they have a rules region. So they are less complicated rules region. They have a region, rules region content. So which means that if you have the value coming from the whole RCEP region, you can largely benefit from the RCEP tariff cuts. So they'll help to reduce compliance burdens, because you look at not only not at a specific country but at the region, RCEP region, when you plan your production. And two, you also have less burden in terms of compliance. And also they are good in the sense of trade facilitation, because they try to push for more streamlined process for the release of goods, perishable goods, and advancing rulings. That'll be good for e-commerce, because you want them to be cleared through the customers as soon as they can. For services and investments, which also relates to e-commerce, as mentioned earlier, they are call for more market opening. But I should say that actually, again, this depends on a case-by-case basis. You have to check, which country you want to enter into, which sector is involved, and then to see whether they have opening up in that sector. For investment commitments, they're scheduled in an elective list, and the parties also are using a positive list for services commitments shall transit to an elective list in 60 years. In 6 years or entry into force of RCEP. And also they have intellectual property. In general, they are trying to strengthen the intellectual property protection. The basic message I think the business or the regulators will face is that they may be good for the regional value chains, because they involve more parties than in the past RCEP +1 FTAs. In the past, it's RCEP have FTA with one country, but now, or with two countries, RCEP Australia, New Zealand. But now you have the value chain extending to 15 countries, and also their first FTA between China and Japan, and so on and so forth. And they also, to some extent, also promote movement of the business people, including processing of applications and transparency. And now let's look at the next slide, which is about the concluding remarks. I also here I have just a paper recently published at the International Lawyer about how to assess regional trade agreements. I found it may be useful, in my view, that to understand how do we explore the implications of the free trade agreements like RCEP for e-commerce and other purposes. I think that maybe we can use three perspectives to look at that. One is the breadth, so how broad does this rules of the specific FTA like RCEP will cover, And the second perspective I think useful is depth. If there are the rules, how deep, or how much density it brings, how really they will change the regulatory landscape. And third one is the strength, that means the intensity, to what extent the rules will be put into use, or to what extent you can ask for, you can resort to dispute settlement mechanism. So let's go one to each of them briefly regarding RCEP from the lens of the e-commerce. So for example, the breadth, I will see that actually the RCEP is broader than the WTO, even if they are, kind of style after the WTO. They're also kind of learning from the CPTP regarding e-commerce in terms of structure. So e-commerce is area where, they have covered properly by the RCEP, and also they address also some other issues related to e-commerce like investment. For the depth, I would say that RCEP may be limited in that regard because, as again, the rules are more aspirational. So there's no real prospect that a lot of domestic law changes will happen because of e-commerce rules. So the business are like to face the status quo they have, but they may have some incremental, hopefully, changes in more transparency, hopefully more leniency regarding data localization and data flow across the border. But also RCEP call for more protection of consumers and privacy. But in general, many of these rules are aspirational or are subject to national security or public policy exceptions. So we'll see how it works at the national level. For the third aspect of strengths, again, RCEP e-commerce chapter is not subject to dispute settlement. So it's more about the willingness of each member countries to deal with that. To wrap up, on one hand, we see that RCEP brings more trading opportunities, because of the liberalization of service sectors, depending on which sector you're involved in, or the cuts of tariffs, although it's spread out in a number of years or even 20 years. On another hand, that I think the effect of RCEP depends on implementation of RCEP by the states and dispute settlements, rule interpretation, and also the cost in utilizing them. So it varies from country 1 to country B. So they deserve more attention, in practice. I think the business in e-commerce and also regulators need to watch out what are the new technologies are used in the e-commerce sector and how the regulation may address that, and also what's the trend of the e-commerce regulation. I think these are probably very important ones. Because I'm about to finish my presentation, but I would like to see that actually what we see that there are a number of questions which will lingering around in this area. A, data localization, whether indeed in practice data localization is required. 2, I think another issue is about, again, cross-border information flow. So to what extent information will be able to flow freely in practice. And thirdly, because these are the rules are subject to national security or public policy, how the different countries have different rules on that, that probably also affects the decision of businesses. And finally, you have other issues like consumer protection and also trade facilitation or tariffs relates to e-commerce. So these are the issues I think deserve more attention. And also, again, I think that's the reason why I think that it'd be great to look at domestic law, as Professor Xu will talk later. So I think I probably will like to stop here, and I do thank you.
Thanks, Han. Thanks very much. Thank you very much. It's indeed a very thought-provoking. Let's shift our, like Han just said, let's shift our focus from international law perspective to domestic law perspective. Then the next topic will be brought to us by Professor Xu Doqi. Her topic is RCEP and its implication. Doqi, please.
Okay, thank you so much, Charlie. And now we turn our attention back to rethinking the notice takedown in China, the e-commerce law. So today I want to discuss the notice takedown rule in China's e-commerce law. This is a very important rule in e-commerce, and the background of intellectual property protection. I will briefly introduce the relevant laws and regulations in China, and then share some typical cases with some opinions. Next page, please. Thank you. And first, let's have a quick look at the notice takedown rule. It is originated from DMCA of America as a tool for copyright holders to protect their rights by sending notice to the platform and asking the platform to remove the content infringing copyrights. This rule was introduced into Chinese law nearly 10 years ago. Now it is incorporated in the e-commerce law in China with an application range of all kinds of intellectual property, including copyright, trademark, and patents. And the CIBEL code also has this rule with some minor changes to what was stipulated in the e-commerce law. Today, I will focus on the Article 42 and Article 43 of the e-commerce law. Next page, please. Article 42 explicates how the notice takedown process operates. The intellectual property right holders notifies the platform to adopt necessary measures, mostly deleting the link of the goods infringing rights. The platform shall promptly adopt the requisite measures and shall forward the notification to the seller. If the platform fails to do so, he will bear certain liability. If the notice is incorrect or malicious, the notifier will have to compensate the seller for the loss. Especially for malicious notice, there will be punitive damages. Next page, please. CIBEL code is newer than the e-commerce law, and it made some minor changes. The notifier has to provide his identity information to the platform when asking, when making complaints. The necessary measures adopted by the platform should be based on the preliminary evidence for infringement and the type of services. These additions made it clearer what the platform should do when dealing with notices. But the core rule remains consistent with what's in the e-commerce law. Next slide, please. Article 43 of e-commerce law is called the counter notice rule. It deals with situation when the seller does not confirm the fact of infringement. So he can submit a statement of non-infringement to the platform, and then the platform will forward the statement to the notifier. If after 15 working days, the notifier does not tell the platform that he has lodged a complaint to the administrative authorities or filed a lawsuit, the platform will end the takedown measures and restore the link. Next page. Thanks. So now we will already have a picture of the rule, the picture of the rules in mind, but how are they operating in practice? There are some typical scenarios. First, the ordinary situation is like that. For example, a garment company is the owner of a trademark. They found that on the Alibaba platform, a store was selling goods infringing the trademark. So the trademark owner made a notice to Alibaba. Alibaba examined the complaint and then disconnected the infringing link and informed the trademark owner of the information of the trading company. Then the trademark owner filed a lawsuit requesting that the seller and Alibaba to compensate for economic losses due to the infringement. The court ruled that the trading company is liable, but Alibaba as the platform is not responsible. The reason is clear here, that the platform has adopted the takedown measures in time. This is a normal case in regard to the rule. Next page, thanks. And the second scenario is that it's wrong notice. Well, the seller can make a counter notice stating that there is no infringement. In the second case, the problem is like that. The seller made counter notice twice, and the platform Taobao determined that the first counter notice was not made within the time limit. And the second time defense was not valid due to lack of evidence. The seller believed that the notifier made a malicious complaint, and Taobao failed to terminate the downgrading measures in a timely manner. So he filed a lawsuit requiring damages. The truth is that the notice was a mistake. The court ruled that the notifiers bears 50% responsibility. Taobao bears 30% damages. So in this case, the court determines the percentage of the responsibility based on the degree of fault of each party. Next page, please. The next type of notice is malicious notice. This usually means the notifier using forged documents and certificates to make a complaint about the goods sold on the platform. After the platform deleted the links to the goods, the seller can suffer huge loss during the great sales day. For example, everybody knows the Double 11 or 6/18. In this case, the plaintiff said he suffers 8 million yuan because the slump in customer flows. Finally, the court orders the defendant to compensate him 2.1 million yuan. So here we can see a practical problem that the economic loss due to takedown measures is very difficult to calculate and prove. Next slide, please. In fact, there is a real problem of abuse of notice takedown rule. The Suling.com is an e-commerce platform in China, and one of its IP engineers released some data about a complaint notice in that platform. During March to August last year, the platform received 189 notices in total, with a daily average of 1.3, but 59 of them were received during June 8 to June 17, just before Great Sales Promotion Day, the June 18. That day, that daily average is 5.9. And we see most unqualified notices were actually sent during that short period, which means the notifiers are really taking the notice as a weapon to gain competitive advantages, and they would give it a try no matter the attack works or not. Next slide, please. To address this issue, China's court take actions preservation as a balancing measure. The fourth case is an example. The right holder believed that the products sold on Tmall constituted an infringement and filed a lawsuit. The court found that the infringement was constituted and ordered the seller to stop the infringement, compensate for damage, and Tmall shall immediately remove the sales links of the relevant products. The seller appealed to the Supreme People's Court. During the second trial, the patent right in question was declared invalid by the State Intellectual Property Office. So whether the patent right is valid remains uncertain. Next slide, please. On November 5th, the seller filed an application to the Supreme People's Court for preservation of conduct, requesting the court to order Tmall to immediately restore the sales link on Tmall.com, and requesting the court to make the decision within 48 hours due to the urgency of the situation as Double 11 was approaching. The November 11, the greatest sales day in China, everybody knows. And within 26 hours after receiving the application for preservation, the court ruled that Tmall shall immediately restore the link to the relevant products. 6 million yuan of the balance in the seller's Alipay account shall be frozen until the effective date of the judgment. If 50% of the total sales of the relevant products of the seller exceeds 6 million yuan, 50% of the sales in excess shall be retained in the Alipay account and shall not be withdrawn. The ruling shall be executed immediately. So we can see that in those urgent situations, the seller whose products have been taken down because of notice can restore his sales by asking the court to adopt preservation measures. Next slide, please. the Supreme Court issued a document guiding opinions on the trial of IPR related civil cases involving e-commerce platforms, clearly point out the status of preservation measures used to solve the notice abuse problem. Preservation measures means the court requires the party to do or not to do a specific act. So for action preservation in China, its function is sort of similar to preliminary injunction in other jurisdictions. Next slide, please. So, but let's think again about the notice takedown rule. The whole system finally are firstly are platforms capable of conducting substantive reviews in patent case in the field of copyrights, as long as the notice of complaint complies with the statutory requirements. It is generally easy for the platform to make a general determination as to whether there's a copyright infringement. However, in the field of patent rights, even if the notice of a complaint issued by the right holders complies with the statutory requirements, it is often difficult for the platform to make a determination on whether the patent is infringed or not based on the notice. As we know, in patent infringement disputes, the professional and technical nature of patents is very strong. So the determination of patent infringement has always been a big difficulty in the trial of cases. And even judges with rich or abundant trial experience are often stumped. Next slide, please. If the platform only conducts a formal review, even if the respondent initiates a counter notice, the right holders still have 15 working days to file a lawsuit, during which the sale link will not be restored. It is difficult to determine the amount of damages for lost sale opportunities due to incorrect or malicious notification, especially during great promotional days. If the platform needs to conduct a substantive reviews, how should the cost burden be allocated? How much incentive does the platform have to devote resources to that difficult work? So this is a question that need to be answered if we want the e-commerce platform to play a good role. Next slide, please. The second question is, can action preservation be a long-term mechanism to address the abuse problem? The court reviews the application for action preservation, taking into account for 4 factors: the applicant's factual basis and prima facie evidence. And the second is the urgency of situation. And third is the applicant's likelihood of success. And the last one is the security provided by the applicant. If the requirement of court review are too high, action preservation will be of very limited use to protect that party. If the requirements of the court review are not high, the whole process is adding unnecessary costs. Firstly, the platform quickly taking down the product according to the notice of the right holder. Then the seller applies to the court for preservation measures and the link is quickly restored. So why not take no measures of takedown in the first place and let the parties resolve their disputes through the courts themselves? Anyway, next page, please. Anyway, in my opinion, for patent infringement, the notice takedown rule should be improved by emphasizing the neutral status of the platform. One possible approach is that upon receiving a notice from the patent owner, the platform should immediately forward the notice to the seller and ask him to provide an explanation within a certain period of time. The platform should tell them that if he fails to do so, the product in question will be taken down immediately. If the seller replies within the specified period that his products do not infringe, the platform should inform the patent owner of the seller's information and let both parties resolve the patent disputes through litigation themselves, and there will be no takedown measures by the platform. When the seller fails to make an explanation by the deadline and the platform fails to adopt takedown measures in a timely manner, the platform shall bear certain responsibilities. So next page. I think it's last page. Finally, let me conclude the issue briefly. The existing notice takedown rule in the e-commerce law has been suffering from serious abuse. Now, the counter notice rule has a 15-day waiting period, and the wrongful and malicious notification can lead to huge losses for the respondents, and it is difficult to prove the amount of loss. The Supreme People's Court action preservation mechanism has somewhat balanced the unequal status of the parties, but may not serve as a long-term mechanism. For patent infringement, the notice takedown rule should be modified to emphasize the neutral status of the platform. That's all my sharing, and thank you so much for your attention. Thank you.
Okay, thanks very much, Doqi. Indeed, very thought-provoking. I personally learned a lot. So next stage is the most favorable. I think I like that stage very much. That is the Q&A stage. Just feel free to ask your questions and send your questions to Q&A sections. Then the backstage will publish them, and I will choose. Usually, I will choose the questions with the most like to ask our speakers first. But this time, I think I might choose the longest question to ask first. Yeah, the question is from Li Xingyue. I think that question is for Professor Wang Heng. She is asking about RCEP's Annex 2 and 3, whether that means China has taken a defensive strategy regarding the innovation of national security regulation. How do you think about China's policies and rules on essential securities interests? Thanks. Heng.
Thank you, Charlie. Thank you, Xingyue, for the question. It's a great one. I think as you mentioned about the question, which is about China's schedule, which indicates that China reserves the right to, to take measures which they consider necessary to protect essential security interests against another party, such as screening of investments if the other party reserves the same rights, to protect their security interest. I think it's maybe a little bit hard to say whether it's defensive or offensive strategy regarding the invocation of such essential security regulations. I think there may have some aspects we can look at that. One, such statements of China's schedule is relatively new, because I think, as far as I understand, that it's not so common for such kind of statement in China's schedule in other free trade agreements China concluded, or in the context of WTO, which may be less likely to be the case because WTO does not really focus more on investment. So it's quite new in that regard, where China pay attention to those kind of essential security and highlight a more obvious situation. And second, I would say that to answer your question whether they're defensive or offensive, I think it's important also to look at, probably the issue is not about who takes the measure or how one respond to that. I guess maybe more the case about, whether the measure taken by any party is justified or is well grounded. I think that's probably more important than who takes the measure first. So I think that's pretty a crucially important aspect. So that have to be analyzed on case-by-case basis, and also depends on the country. And thirdly, the issue is about national security or national interest. About your second question, I think these are the issue varies from one country to another country. One of the major problems for RCEP at this stage, I think, it's kind of early harvest agreements. It doesn't really provide very detailed rules, hasn't really touched upon how do we interpret national security. And so at the end of the day, it's left to the different countries to decide. And they have not dealt with issues like source codes and so on and so forth. So I will conclude here saying that there are a lot of uncertainties. It's hard to predict, the China's policy or other countries' policy in this regard. But what we will see that's like to be uncertainties due to technological innovation in the e-commerce and other sector, how you regulate, but also international relations, as already seen in the past several years. So the business have to watch out for the trend and act strategically. And also a final point is that even for China also is both importer and exporter. When China exports, they probably don't want to have data localization, probably don't want restriction on movement of information. But when China is an importer, when China is a regulator, the story is totally opposite. So China is also have to strike a balance, between those two total opposite positions. Ensure that your business, e-commerce business, going outside without restrictions, while you also want to regulate someone come to your country. So it's a very tricky issue, and will remain to be seen. Thank you.
Thanks, Cheng. Then the second question, the second longest question, is from Bell. In the trade friction between China and the United States, intellectual property rights are an important concern of the United States. I think this question is for Professor Xu. The United States has been accusing China of ineffective protection of intellectual property. Does the problem you mentioned today have any connections to the pressure from the United States? How do you see the role of America in the whole process? Professor Xu, please.
Okay, thank you, Charlie, and thank you, Bai's question. Okay. That's a very important issue, I think. America published a series like 301 report and criticized China's legislation regarding to the intellectual property. But anyway, we can see China has made a lot of progress in IP protection now. And honestly speaking, some rules in China's law did learn from America, or were established and some influence from America. For example, in the economic and trade agreement between China and the USA, intellectual property is the first chapter. And the effective notice and takedown system is required for China to combat the IP infringement. So maybe there are some issue in the level of intellectual law, but I don't think we should limit ourselves by those specific rules. We should, for example, develop a system that works well in China's market environment. The legal test could be technically interpreted so that we can balance like IP protection and market fairness, without harming the rule of international laws. And actually, the focus of the notice takedown system in American law's view is copyright infringement. It is not necessary for China to apply that rule in the field of patent protection. So I think, to some extent, the pressure from America helped balance the protection of IP in China. But China should keep our own way or our own pace and make an independent judgment regarding what the law should be like. Thank you.
Thanks, Doqi. Thanks to our speakers' well time management capability. I think we still got time to ask 1 or 2 questions. Let's see. The next question is from Shang Xuan, I think. The first part, it's anonymous. I think it's for Heng. I have a question. Will trade agreement like RCEP and the CPTPP converge regarding e-commerce rules, and what are the implications for businesses? Heng, please.
Oh, thank you. I think it's a great question in the sense that actually, as mentioned earlier, the RCEP and CPTPP, they have a kind of similar structure to some extent. However, if we look further down further into that, it's quite different in the sense that TPP, or CPTPP tries to set a minimum standards, and also they have much more stricter rules in terms of prohibition of data localization and promotes the data flow. That reflects largely, for example, the US approach to data or to digital trade. RCEP on the other side trying to be a light touch. Actually, I would see that differ much more to the regulatory autonomy or the position of the parties. So I still think there's a quite different position between RCEP and the CPTPP. So for example, RCEP, I think in my view, will be unlikely to bring many substantial changes in the domestic law in that regard, while TPP will bring a total different story if you apply to the same country. Then they come back to the issue that what are the implications for businesses? So I think that's still like the case that the business will be facing, unfortunately, quite divergent regulatory approaches among different regions, particularly in different countries. So which means that you probably have different compliance or requirements, and that brings additional costs. So I think I would suggest actual business to watch out, the trend in that, and also bear that in mind when you conduct business and when you plan your businesses, and also take a wait and see approach to some extent. We'll see how RCEP will implement in the practice. But again, I will see that uncertainties are likely to arise to foreseeable future. Thank you.
Thanks, Hen. Then the last question I would like to ask Professor Xu. The question is the malicious notice is kind of like an unfair competition action. Is there any thing that is applicable in Chinese competition law? Yeah, please.
Okay, thank you for your question. I think I'm not expert in this area, but yes, indeed, the abuse of the notice takedown rule is in fact an improper attempt to gain a competitive advantage. In the case of malicious notice, we found that the court's decision was also based on the anti-unfair competition law. First of all, there is a provision indicating the principle and the spirit of the law, but this is more of a general description, which means the operators should comply with the business ethics. In addition, the anti-unfair competition law classified unfair competition into several types, including the rule that operators shall not fabricate the false or misleading information to damage the reputation of their competitors. This is probably the closest description of malicious notice, and some court decisions have cited this provision. Perhaps we can consider the takedown of goods as a result or cause of reputation damage. Of course, the description of the law is not exactly the same as malicious notice. It is important to note that also the court cited the anti-unfair competition law, the law that ultimately allows the plaintiff to recover damages is the e-commerce law, especially punitive damages for malicious notice is all in the e-commerce law. If malicious notice is found to be an act specified in the anti-unfair competition law, then the administrative agency can improve penalties, can impose penalties according to the law. That's what I think. Thank you.
Thanks, Dochi. Everyone, time flies. I believe you all enjoyed the session very much, and the time is too short for us to discuss all the questions from participants. Platform operators are probably the most critical objects of regulation in e-commerce law. Notice takedown as a compulsory policy is required by China's e-commerce law, which has been implemented for 2 years. However, while enhancing intellectual property protection, this rule has also caused unexpected results in practice, which is online sellers utilize it as a weapon against their business competitors, usually right before the sale promotion day. What are the legal roots of the problems over here? How are the courts dealing with it? Where can the legislation be improved? Professor Xu explored some alternative answers to these questions. Also, RCEP is one of the largest trade agreements in the world. It affects a wide range of issues, both international and domestic issues. E-commerce is a crucial aspect of RCEP. Understanding RCEP and its implication are critical for us. As Heng mentioned, on the one hand, RCEP brings us more trading opportunities. On the other hand, the effect of RCEP depends on the implementation of RCEP by the states, dispute settlements, rule interpretation, and costs in utilizing RCEP by businesses. They are especially true in the e-commerce arena. Both topics being discussed are vital for us to understand the implication of e-commerce and RCEP. They also will evoke more, I think, a discussion in academia. I believe e-commerce relevant regulations, although it is developing, will bring the world more prosper rather than conflicts. Last but not the least, I need to thank CIBEL for the excellent chance for us to discuss e-commerce and RCEP over here. Also, I owe a big thanks for both speakers for the great presentations today. Additionally, without our excellent CIBEL team, Fionn, Henry, and Sophia, this webinar will be much harder to be organized. I'm sincerely appreciative of what they've done for the webinar. More importantly, thank you very much for participating in today's session. Have a great day, and maybe see you in 2 months. Thank you. Bye-bye.